Well, I'm a commercial lawyer specializing in financial law, transactions, and so my entire practice has been advising on transactions, the legal aspects, obviously. I've also a significant advisory component to my practice, and I've felt over the years that slightly frustrated that I'm constantly thinking hypothetically about the law as it applies to facts, and I thought it would be interesting, challenging, attractive to have the opportunity to get in the weeds into real disputes and actually decide how the law in fact does apply to specific sets of facts, to specific disputes. And I have found that to be true, that as a judge, I feel I have a deeper connection with the law. So it does help if you love the law, which I do. And I felt it's made me a better lawyer. And I do think it's in a way a purer form of lawyering, purer than being a solicitor, even a litigator, even an advocate, even an academic, because I've also done some academic writing. You know, it's a real chance to just be focused on the law, obviously in its commercial context and taking into account the wider community and social interests and so on. And how did I get there? Well, of course, for many years I thought, you know, the opportunity to sit as a judge simply wasn't going to ever be available to me given my practice. But then I discovered in sort of the late 2000s that in fact the JAC was encouraging non-litigators, non-advocates to apply, and in fact discovered there were some prominent examples of that. Alexandra Marx, for example, being a prominent example. And that was encouraging. So then I began to think seriously about it, and thinking seriously about it, I thought, well, I've got to get into court. I was in court occasionally in connection with my transactional work, but rarely. But to get into court and to start reading about the different possible paths that I could take, and I finally settled on applying to become a recorder in a competition looking for recorders for the Crown Court, and I went from there. Well, there are of course many challenges to applying for a judicial role and becoming a judge, and particularly if one is not a litigator or an advocate. You've got to obviously learn procedure well. You've got to learn the rules of evidence well. You've got to develop some court sense, which again will come perhaps more naturally to advocates, but to other lawyers that's something they're going to need to develop. In order to, once you've decided on what path you're going to take, you then need to get familiar with the specific requirements of that path, whether it's family law or criminal law, or public law, or something else. So you need to do a lot of reading. You, of course, need to get appointed. So you may also need to do some training in order to prepare for the process, whether it's interview training or role play, and get comfortable with all that. You need to get comfortable with being out of your comfort zone. I think people who've been in practice for a long time lose that sense because we're not often out of our comfort zone anymore, and you are going to be out of your comfort zone a lot, both going through the process of applying and also actually doing the job of being a judge. And so get used to that. And in a way, overcoming those moments of feeling out of your comfort zone are actually part of the fun and the challenge, and makes it even more fulfilling. There are a number of tips that I have for getting there, but I think one of the most important ones is knock on doors, talk to people. Don't be afraid to ask for advice. A lot of people who approach me for advice, because I've been a recorder for 7 years and a deputy high court judge for 3 years, a lot of people who approach me are very diffident, as though I'm too important and I wouldn't really want to give them the time. And of course, I love meeting people, I love talking about it, and I'm always willing to give the time. And I've actually found when I've approached others, High Court judges, circuit judges, other fee-paid judges, everyone is happy, almost without exception, to really give time. So knock on doors. And in fact, that was advice I had from a High Court judge early on. Knock on doors, talk to people, and get all the advice you can. Do a lot of reading. Don't underestimate the amount of reading. Do it. Keep doing it. I suppose there's a number of other things, but I think those two things, along with spending time in court, will set you up well for meeting the challenges and hopefully getting a role. My single bit of advice, which is really aimed at non-litigators and non-advocates, is get into court. Apply for formal work shadowing, but don't hold your breath, because there's a lot of pressure on that program and you won't necessarily get that straight away. But do apply for the formal work shadowing. It's excellent. But also, if you can get informal work shadowing with any judges you know, do that. And if you can't get that, sit in the public gallery. Just get into court, get court sense. One refinement on that, I'd say, is that in practice, I find there is a bit of a law of diminishing returns. So when you go to court, don't feel you need to be there all day. The first hour is probably going to be the most useful. The next hour also useful, but a morning is probably sufficient. But then do several mornings and just get into court. And I think that really is the if I have to give a single bit of advice, that is it.